We're ready to start. Let me make a few announcements before we start. Welcome everybody to our first hybrid meeting, getting back after the whole 2 years of the COVID thing. We've got a new member here tonight, and that's Tikas, sitting to the right of me. And as I explained to everybody, and you saw it on the flyer, you could do this meeting either in person or Zoom. Since it's St. Patrick's Day, we decided to do it hybrid, and we have several members here, which is great. And so the people that are here at the Marie Callender's in West Covina are going to be ordering off the menu and having dinner during the meeting. Sorry, Scott, we'll try to be quiet as we're eating. So this is a huge experiment on our part, getting back together. It's the first time we've done this, so my apologies to Scott. Thankfully, he's a member. He's been a past board president and held every position on the board. So I think he's flexible on what we're doing. Thank you, Scott, for sticking with us and being flexible about the meeting tonight.
Not a problem. We're more than happy to accommodate.
Thank you. I appreciate it. So Scott's office is in Claremont, California. He specializes in employment law, and Scott's going to be doing a presentation tonight. It's an hour of general MCLE. Everybody here at the meeting got their sheets so they can save them for the bar to prove they were here. And there's a sign-in sheet over there too. And then everybody that's appearing Zoom tonight, you'll get yours online after the meeting will be sent to your email. So with that, I'm going to hand it over to Scott Wheeler on employment law. Scott?
Great. Lori, thank you very much. And it's actually a pleasure. And it's encouraging that members of the Eastern Bar are actually meeting in person. It's really good to see after the last 2 years. This program came together actually with a prior past president, Carl Herbald. Carl and I gave a program. It's been about 15 to 16 years. And what we wanted to do after that program was put something together that is relevant to each of you in your practices. Almost like a toolbox, so that when you can refer to specific documents regarding hiring, you could look at or refer to policies and procedures, as well as to have documents related specifically to issues that may come up for disability of employees or even unemployment. So this program this evening is geared towards 2 specific areas. One, it'll be a toolbox for you. You'll have, and you should have received documents or a link of documents that will be helpful to you in each of your practices. Some of the policies and procedures will apply to situations for those of us that have 5 or more employees. Other documents that you'll see will apply to any employer where there's 1 or more employees. After we go through what I call the toolbox as far as the documents, I'll discuss with you the updates of 2022. And there have been a plethora of things that are happening relating to wage and hour, relating to, some of you may know what's called PAGA, or the Private Attorneys General Statute, in addition to mask mandates that we've dealt with, as well as changes that are happening regarding potentially mandatory vaccination for employees. So we'll go through each of those this evening. After the program, I will stay, I'll answer questions. I know we have a chat function. With the program and the materials that I'm going to cover, I'm going to hold off on responding to any of those questions. If you want to ask a question that I can respond to after, please go ahead and insert your question. We'll go back. If we don't have time to cover and go through all of your questions, please, I encourage you, email me. And either I'll call you or we'll set up a time and I'll respond back. The other aspect that I'd like to discuss, and just briefly, the materials that we're going to go through, quite frankly, are based upon questions that I've received from many of you, from other attorneys locally, to address specific issues that arise. So with that being said, I'm going to go ahead and share my screen with you, and we'll jump right into it. So first, when you decide to hire an employee in the state of California, you're required to provide them with notice under what's called Notice of Wage Theft or Labor Code Section 2810.5. And this notice, what it provides are essentially the terms and conditions of employment of the employee and the employer relationship. It'll discuss, as I'm sharing with you, it sets forth the actual name of the employee, start date, the legal name of the hiring employer. If this is a corporation, an LLC, partnership, the best way to verify the name is to check with the Secretary of State, and that'll give you the full legal name. Scan down, this form also requires wage information, hourly, salary, commission, whether or not a written commission agreement exists, which it should, but it describes the compensation. The next part, workers' compensation carrier, must be identified, as well as paid sick leave as discussed. So this form is required to be signed by the employer and provided to the employee at the time of hiring. This document turns out to be very important, as we'll discuss once we get into the wage and hour section of this evening. The next document that quite a few employers do not provide to employees or report to the EDD is actually the form that you have before you, and this is actually a report of new employees. This document must be provided to the EDD within 20 days of hiring of the employee. So this would include someone that provides services, for example, to answer your telephone, even if it's 5 to 10 hours a week, even if it's 2 hours, even if it's 30 minutes, quite frankly, this form should be completed and forwarded to the EDD. And you may think, okay, why? Well, this starts the process for purposes of, quite frankly, employment taxes for the state of California. There's another form that I would encourage you to take a look at, and it's related. It's a report of independent contractors. Anytime an individual or his or her business, company, or otherwise provides services to your practice office, this form must be completed as an independent contractor where the services exceed $600. This particular form is a self-reporting form. So, what happens if you put down a law clerk, an associate, as an independent contractor, and you file this with the EDD? More likely than not nowadays, it'll turn into an audit, the question of whether or not this person has been classified correctly as an employee or independent contractor. So from the standpoint of this particular document, it's important for purposes of classification. Once again, for my purposes in wage and hour, I'm looking at whether or not the employer actually did this correctly. But for our practices and how we classify our staff, how we classify those that are providing services for our office, it's very important. Very just generally speaking, I want you to take a look at the W-4 form. This is important as well. It's been updated. It was updated last year. It's not just the one page that we're used to. It has a series of, as far as instructions and as far as listings and requirements. I encourage each of you to take a look at the first file that's identified as hiring documents. Hiring documents. One item that I included in this particular handout used to be located on the California Department of Fair Employment and Housing's website. The Department of Fair Employment and Housing is the administrative agency that regulates discrimination in employment and housing in the state of California. As you'll see, they have a number of handy forms as well as policies that are applicable to each of your practices. But this is a nice form that provides certain employment inquiries and questions that can be asked that are consistent with California law. And those questions, of course, relate to hiring and certain questions that can and cannot be asked of your employees and staff. I will just tell you, though, on page 3, one of the questions relating to arrest or criminal records, that is outdated because of ban the box. Questions can't be asked now as far as criminal records, et cetera. So this section is outdated. Once again, this form was pulled by the state a couple of years ago, but I feel it's pertinent for each of you to take a look at is when you're considering hiring staff. One other form that was updated, and this is the I-9 form, and this is also another one of those self-reporting forms, but you need to keep in mind that this particular form needs to be updated, and it's something that you keep in it would be in the personal file of the employee, but make sure, and this is done even with one employee, that you have your I-9 form in the personnel file. It's not submitted to the federal government. It's not submitted to the state of California, but it's an important form that you must have in the employee's personnel file. So you've hired your employee, and this person's providing services to you. It could very well be somebody that comes to your office to help out Friday afternoons. They're helping you organize boxes. They're helping answer the telephone. How do you deal with the payment of wages? Well, the state of California has 17 different wage orders. And you may think, what exactly is a wage order? And a wage order for our profession is wage order 4/2001. But what it is, it defines the rules and regulations of the workplace and how compensation is to be provided, such as minimum wage, overtime, meal, rest periods, employee reimbursements. And just to briefly scan down, I'll show you and highlight the headings of this document. So you can see from section 1, you've heard of the exemptions: executive exemption, administrative exemption, professional exemption. Those are areas that are exempt from the payment of overtime wages in most of the regulations in this article. Attorneys, licensed attorneys are exempt, so these provisions in this document would not apply. But to scan down, let's look at hours and days of work. This covers minimum wage and overtime. Section A, 3A, deals with overtime, double time. There's provision regarding alternative work schedule, which goes beyond our practices, but to scan down, minimum wages. And although this regulation wage order was enacted in 2001, the state updates these wage orders so that everything is up to date regarding minimum wages, et cetera. This document should be posted in an open space in your offices if you have just one employee, just one, or in a binder, and we'll go through that. This also covers records, and you may think, okay, what records? Well, wage statements, pay stubs. Those of you that may have a service that prepares the wage stubs, a company, Paylocity, so that they're maintaining your records, or you may maintain your record yourself. That's fine. There's nothing wrong with that. But this covers how records are to be maintained, how they're to be provided to the specific employee, et cetera. Just going to scan down meal periods and rest periods. course, from my practice area, these are two issues that come up quite regularly, but the wage order also provides, and I would encourage each of you to take a look at meal and rest periods and how it relates to your practices and whether or not you are in compliance. Another aspect and something that's been contested, and it's an issue that I see pop up more and more now, is suitable seating. And don't think of necessarily disability or accommodations, just whether or not a suitable chair or something else has been provided to your employees. That is an issue that pops up in most of my wage and hour cases. The reason why I bring this to your attention is because I've received calls over the years, and I'm just going to scan back to the top, where somebody may have a former client, a friend of a friend that comes into your practice or comes to your office and says, hey, can I help? And maybe you let them move boxes around or otherwise. And the question is whether or not that person could be considered your employee. And I submit to you, under the wage orders and how they are, if you really consider that employee means to engage, suffer, or permit to work. If somebody comes to each of your offices and they're there and they're engaging and you're allowing them to work, they're going to be your employee, more likely than not. And the situation that I've seen common and regularly is where somebody comes to an office on the Friday afternoon and moves boxes into storage, and they're paid maybe $10 or $20 for 4 hours worth of work. No breaks provided, no meal period, and they're paid less than minimum wage. So you can start to see the numbers just for one day could add up. The way this type of this regulation wage order is enforced is either by a complaint to the Labor Commissioner, Division of Labor Standards Enforcement, or by a civil action. And so the civil action also could seek penalties, and there's a provision for penalties under this wage order. For our purposes, I encourage each of you to take a look at this wage order, and really assess and use it as a checklist as to whether or not you're in compliance. Another form or specific document that employers are required to post is a payday notice. This document is available right from the Division of Labor Standards Enforcement website, and you're to notify your employees as to the days they're to be paid. And once again, this document should be posted. Now, it references Labor Code Section 204, and I submit to you that a cause of action pursuant to Labor Code Section 204 is not actionable because the statute does not provide for an individual private right to sue for that violation. However, the Labor Commissioner can enforce it, and also an injunction, as far as an injunction, mandatory injunction, could certainly be brought to enforce this section. But I encourage each of you to take a look at this and determine whether or not you're in compliance. The other document, and this is also straight from the Labor Commissioner's office, and it is an example of a compliant pay stub. Some of us, don't necessarily want to pay for a third party to prepare wage statements because of the cost and the price, especially after the pandemic, and whether or not the services that are being provided are even consistent with California law. This is an example of a legally compliant wage statement. And I'll tell you, when I first saw it, it bothered me because, number one, Labor Code Section 226 requires the wage statement to show the total hours worked. Well, this example does not. As far as current case law with Labor Code Section 226, I will tell you that it is compliant. and it covers the bare minimum requirements, provides for the company, the employee, social security number, most importantly, the pay period and the hours, as well as the sick leave. So when you go back to your offices tomorrow, take a look at your pay stubs, your wage statements, whether or not they're compliant. If they're to comply with Labor Code Section 226, it's $50 for the initial violation. It's $100 per violation thereafter. The statute of limitations for a non-compliant pay stub is 1 year. So I encourage you to take a look and self-audit whether or not you're in compliance. After you have your hiring documents, you're in compliance with the California Labor Code to the extent that's possible, you have to look at whether or not you have a harassment policy and discrimination policy in place. Now, I've mentioned the Department of Fair Employment and Housing. The Fair Employment and Housing Act is the statute that's regulated by the Department of Fair Employment and Housing that relates to discrimination and employment. Under California law, Government Code Section 12940 at SEC, employers are subject to the Fair Employment and Housing if they have 5 or more employees for purposes of discrimination, for purposes of providing the California Family Rights Act, disability related matters such as engaging in interactive good faith process, as well as accommodations. And for most of us, we may not have 5 or more employees. However, there are certain regulations that come up in our practice on a regular basis. So you're going to see, and I would encourage each of you to take a look at the handouts and determine whether or not any of these apply to you. I would tell you one document that I found, and it's on the Department of Fair Employment and Housing's website. It is a policy. It was last revised 2018, so I'm sure this will have some provisions that need to be updated, but it's a sample policy. And it goes over and covers the protected classifications of the state of California, as well as federally. And it provides enough information so that you can have, for your practices, have a policy in place. I would also tell you that there are posters through the Department of Fair Employment and Housing's website or handouts that are also in the materials. I'm just going to switch back. And for example, employment discrimination based upon disability. These documents themselves consist of policies. They discuss as far as the requirements of the law, it discusses how to make a complaint, as well as the persons that are protected under the statute, being the Fair Employment and Housing Act or Government Code Section 12940. So that if you have more than 5 employees, you can certainly use these specific handouts or posters as far as your policies in the workplace. So that if you don't have policies in place right now, you should. As I indicated, these policies apply for employers that have 5 or more employees. What about the situation though for harassment? For purposes of harassment under the Fair Employment and Housing Act, it just takes one employee. So the obvious one is sexual harassment, but you can certainly have harassment based upon a disability, age, of course, is related also with regard to sexual orientation, gender, etc. So that these policies are pertinent for each of you and your staff to make sure that you are prepared if something were to happen. For example, if there was a complaint to be made. The law used to be that an employee had 365 days to file a complaint with the state of California, specifically the Department of Fair Employment and Housing, but that changed a few years ago, and it is now 3 years. From the date of the last discriminatory act, that generally speaking is the last day of employment, 3 years. So quite a lot of things could happen over a 3-year period. Memories fade, folks move, changes happen. So just keep in mind 3 years. So how important is that for each of you, for each of us to have our policies in place to maintain records of these policies? One area that I receive calls about quite often deals with what happens when one of your staff members has a disability or they have to go out on disability leave. And it's likely happened to many of us. And what do we do? And what sources, what resources are available to us? What does the law say? And as I indicated, for purposes of accommodation for disability, discrimination applies to 5 or less. However, there's that question of wrongful termination and whether or not if an employee is fired for disability when you have less than 5 employees, when the Fair Employment Housing Act doesn't apply, but there's still that question. And it goes along the lines of, staff member files a disability claim with the state of California, and they tell you they can't return to work for 30 days. Well, I encourage you to take a look at government code, and I've included this for you. Government code section 12926, specifically section U. And an employer is required to accommodate an employee so long as it doesn't create an unnecessary undue hardship. And although this section relates to employers that have 5 or more employees, it's certainly pertinent to each of us in our practices if we do have a staff member that is out on disability, where the doctor is refused to provide a return date. And the doctor's note just says, employee's out, employee will be out on disability. The doctor will update within 30 days. Now, there's not a specific case on point that deals with how long does that accommodation have to be. But you will find federal cases that discuss that disability should be beyond 6 months. Disability does not have to be for an indefinite or infinite duration. But next time you have that issue come up and you're worried about how something's going to be done, how are you going to afford to hire somebody else when you can barely have the staff that you have? Consider undue hardship and those factors and whether or not they apply to your practice. Another area that comes up quite regularly in questions that I receive relate to unemployment compensation. Generally speaking, the presumption is, quite frankly, that employees are going to receive unemployment benefits. And we don't always look and think about, okay, what steps can be done to try to prevent unemployment benefits for a problem employee? As most of you know, employees in the state of California are presumed to be hired on an at-will basis, meaning that they can be fired at any time, they can leave any time, we can let them go and tell them good luck, and they can do the same to us. However, unless it's under contract, but for purposes of unemployment benefits, an individual or an employee is presumed to be discharged for reasons other than misconduct in connection with their most recent work. And what that means is the presumption is that they were they were discharged for reasons other than straight misconduct. You may think, okay, what is misconduct? How do you prove misconduct? Well, the obvious ones are stealing, lying. But I submit to you, this goes back to even before a case that I encourage you to take a look at Cotran, that we're encouraged by unemployment code section 1256 to engage in progressive discipline of an employee if your intent is to try to prevent them from receiving unemployment benefits. And over the years, we've all had that specific employee that didn't necessarily finish their work in time. Maybe they missed a filing. It's not necessarily consequential, but it certainly could impact a case. So what do? You can't necessarily, you want to just fire them, but you're worried about unemployment. So then under Unemployment Insurance Code section 1256, if you engage in the progressive discipline, in other words, and you're writing them up and you're specifically disciplining the particular employee for their misconduct, you have an opportunity at the time, if you do, in fact, terminate this employee, to show that it was actually misconduct that was the reason for the termination and not something else. Another issue that comes up is if somebody voluntarily leaves work, they quit and they say they had good cause to quit. That's similar, analogous to what's called constructive termination in violation of public policy. In other words, they were forced to quit. In the unemployment setting, it doesn't have to relate to a public issue. It could be something entirely private. You may think, well, what is that? The obvious one is if they're not paid their wages, it's public, but also quasi-private because they're not being paid correctly. It could very well relate to a mask mandate if somebody quit because other employees were not wearing their mask or they were not vaccinated. But these are issues that come up in the situations where you have the employee that leaves and they say that they were forced out. And it's fact specific. I've included the statute, but as you scan down, I've also included the 22 pages where cases are cited. So I encourage each of you during your own time to take a look at some of the cases and what qualifies and what constitutes good cause. From my perspective, and not a lot of people know this, but anything that takes place in the unemployment setting is considered confidential by statute. And what we're really talking about is the EDD, the Equal Development Department. If you let go or an employee is fired and they file for unemployment, the EDD will contact you and ask you as the employer, what's your position as to the employee and why they were fired. The EDD will conduct a report, and that report is used to determine whether or not the employee is provided benefits. If there is an appeal, so that if benefits are provided and the employee decides to appeal or the employer appeals, there's a hearing. And it about 15, 18 years ago, it started to change where the hearings actually became quite adversarial, where employers started to show up with counsel. And the employees were unrepresented and responding to questions of good cause on their own. For me, it's a treasure trove of potential information, because if you have an employer representative that shows up at one of these hearings, you can obtain quite a bit of information. The question always is, though, whether or not there's a waiver. There is case law that talks about that an employer can waive Unemployment Insurance Code section 1294, as well as an employee based upon a claim of wrongful termination. But for our practices and from our perspective, just keep in mind that the door can be open, and this as far as privilege could be waived. So just keep that in mind depending upon the information that's released and what's discussed at the time of hearing, if it goes that way. And keep in mind, all hearings are recorded. The hearings are conducted by administrative law judges, and you can certainly request the recordings if you are a party to the hearings. We're going to switch gears, and we're going to go through now as to what's happening in 2022. I wanted to, initially when I started putting together the program, it was going to be the not so update for 2022, but it's 2022 has turned out just to be totally opposite. But let's take a look at COVID first and what's happening. First of all, I'm sure most of you are aware, COVID supplemental sick pay is back in favor. Unfortunately, it doesn't apply to most of us because we don't have 26 or more employees, but we may have clients that have those number of folks. You may have to potentially deal with this issue with a potential client if the employer is not compliant. But I've included the most updated poster for you to take a look at. It's actually the handout from the Department of Labor and goes through all the requirements. The one thing that I want to bring to your attention, and this is an issue that is problematic for employers, is what's called regular rate of pay. Regular rate of pay. And what that refers to is, as relates to a case that came down last year, Fiera versus Hollywood Hotel. And that means that if an employee receives non-discretionary incentives, commissions, the overtime rate of pay, the sick leave rate of pay has to be adjusted. So it's not just the hourly rate the employee was earning. So if somebody was paid $15 an hour and they go out on sick leave, they don't receive commission, they don't receive any additional incentive pay, fine, it's $15 per hour. But what about the employee that receives $15 per hour plus $1,000 for bringing in 2 or 3 clients? Or if you provide Christmas bonuses to your staff based upon performance, where it's not discretionary, where it may not change, but you provide it yearly and it's always the same. And then you write down for 80 hours, the regular rate of pay would have to be adjusted. And this carries over to the payment of wages as well to your staff, so that if you do provide a incentive, non-discretionary commission or a bonus, their overtime rate of pay would have to be adjusted as well. So if that's something that's happening, you need to take a look at whether or not your overtime rate of pay is accurate. Next, related to COVID, and this is something that has been in the news the last 2 weeks, and I encourage each of you to take a look at. This is AB 1993, and it's currently before the state assembly. This would require all employers to mandate their employees be vaccinated. We can certainly have many discussions as to the reasons why this is the right thing to do or wrong thing to do, but this is currently pending in our state legislature now. And I wanted to bring this to your attention. You could certainly take a look at it and review it. It does provide, the statute does provide for reasonable accommodation, whether or not somebody wants to be vaccinated or not. But those cases right now dealing with the mask mandates, dealing with mandatory vaccine policies, are just starting to get through the courts. And what I'd call they're almost test cases to see what is going to be what will happen, how will the courts respond. So I encourage you to take a look at this statute, and you can certainly track what's happening. But this statute would be included in the government code section, which is under the Fair Employment and Housing Act. There's a case that came down, and this came down February 24th, 2022, Bzina versus United Airlines. And this case related to an individual who worked outside, and he was responsible for taking care of the cargo, processing baggage. And this particular employee, Bzina, claimed he needed an accommodation from wearing the mask because the mask that he was wearing impacted his ability to work, and he wanted a reasonable accommodation. United Airlines denied the employee's reasonable accommodation, and the employee filed suit. Well, the United States District Court for Central District, specifically Judge Walters, said, no, your request for accommodation is denied. The reason being is that we're in a pandemic. And the fact of the matter is, if we let you walk around without a mask, that freedom is outweighed by the fact that we don't want the spread of the pandemic of COVID-19 to continue. So the court applied a analysis and a balancing test and determined that the accommodation for this employee was denied and the employee had to wear a mask. And once again, I tell you, this employee was outside LAX and wasn't around a lot of employees. It's an interesting opinion. It's one of the first ones that's come down. So I would highly recommend you take a look at it. And, for each of your practices, I know that LA County, the mandate is over as far as inside internally, but, try to keep an eye on what's happening and predict, okay, if there's an impact in an increase in COVID and it's happening overseas now, how will that impact our practices? And especially if our state and the legislature decides that every employee has to be vaccinated. And so that if you have to go through this balancing test and accommodation, even with one employee, what's the likely outcome based upon current law? Let's go into the 22 updates, and there are a number of things that are happening dealing with wage and hour, dealing with employee theft, and I'll go through those as time permitting. The one case that I want to bring to your attention is Lawson. This came down a month ago, a little over a month and a half ago, Lawson versus PPG Architectural Finishes. And this was a case where an employee brought a retaliation claim under 1102.5. And that relates to, under labor code, it's a statute that provides for whistleblowing where an employer is accused of violating a specific statute or law, rule, or ordinance. And the trial court was going back and forth as to what test should be applied. Many of you may be familiar with what's called McDonnell Douglas. And in that situation is where an employee establishes a prima facie case of retaliation where the employee is engaged in protected activity. They complained. The actual protected activity is the cause and fact of the employer's actions, and there's an actual event, a retaliatory act, a termination. After that's demonstrated under McDonnell Douglas, the employer has the opportunity to articulate a legitimate business reason for the action that impacted the employee. After the employer demonstrates that business reason, the employee can attempt to establish what's called pretext, meaning that the reason provided by the employer is in fact a lie, it's false, untrue. Well, the California Supreme Court said not so fast, and that analysis does not apply to 1102.5 violations. And in fact, we're going to apply 1102.6. And under 1102.6 in a civil action, if it's been demonstrated by a preponderance of the evidence, more likely than not, right? And that scale's just tipped by a hair. Then under this statute, the activity described in 1102.5 then is determined from the standpoint the employer. The employer has the burden of proof by clear and convincing evidence that the alleged action would have occurred by legitimate, independent reasons, even if the employee had not engaged in activities under 1102.5. So it switches the standard and puts it on the employer. And keep in mind, it's not preponderance of the evidence for the employer to prove now their legitimate business reason. They have to prove that legitimate business reason by clear and convincing evidence. So it changes the landscape for 1102.5. And there is not a limit for employees under this statute. For example, it could be one employee that complains. And if the employee complains because people in the office are not wearing their mask and they feel that it's wrong and they're violating state's ordinance, if mask mandates come back into play or before the mask mandates were terminated, certainly a statute like this would provide a remedy for the employee if they're in fact fired or if they claim constructive termination, and it flips the burden of proof. So keep that in mind. Another case I want to bring to your attention, and this is an interesting spin. This is a case that came down in January 27th as well. Now, we've talked about briefly at-will employment, and employees in the state of California are presumed to be hired on an at-will basis. And it used to be, prior to this case, that if an employee tried to bring a fraud claim or a misrepresentation claim against an employer, the defense was always, well, you can't have justifiable reliance based upon the fact that the employee is hired on an at-will basis. And in this case, it related to representations as to the type of work the employee was going to perform. It also went as far as to discuss that the type of work would be long-term. And in this case, the court found that the at-will language, the at-will hiring of the employee did not negate justifiable reliance, so that the employee was certainly justifiably able to rely on the representations of the prospective employer at the time of hiring. So this case decided that under Labor Code Section 970, which relates to pre-employment representations, that a claim would exist. I would encourage you to take a look at this. This is up north in the First Appellate District. It's called Kenneth Allen White versus Schmuel. It's in the materials, but certainly take a look at this case. Next, I want to bring your attention to what's happening with the Private Attorney General's statute. Most of you have heard of PAGA, and PAGA could impact our practices if we have one employee. There's federal case law that provides that an employee can bring a claim for a violation of the California Labor Code, in addition to a PAGA claim, even if it's just their own violations. There's case law to support that. There is a case now that was taken up by the United States Supreme Court. It is called Viking River Cruises versus Mariana. And this case dealt with the situation as to whether or not, if an employee is required to sign an arbitration agreement, can the arbitration agreement also include PAGA claims, or what are specifically referred to as representative actions? Currently in California, under a case called Iskinian, PAGA or actions pursuant to the Private Attorney General Act are excluded. They are considered a qui tam action where the state of California is a real interest or a party to the case. And if the state of California does not in fact sign the arbitration agreement, then there's no way to hold the state to that provision. Specifically, the question that's going to be decided by this case from the standpoint for each of us is whether or not, pull up the question presented, is whether or not the Federal Arbitration Act preempts California law. And so that PAGA actions or third-party arbitration agreements, bilateral arbitration agreements, can be enforced to exclude PAGA actions in arbitration agreements, so that if an arbitration agreement provides that the employee is required to go to arbitration, they waive their right to bring a class representative or PAGA claim, the Federal Arbitration Act trumps that. And I would tell you, this case is set to be argued at the end of the month. I believe on March 30th is the date. And if you have a chance to listen to the arguments, it's a very interesting issue. As far as the briefs, you can pull up the briefs online. So I would highly encourage you to take a look at it. I'm going to go back. PAGA is under attack. And another area that that folks are trying to change and modify the statute is by the Californians for Fair Pay and Accountability. And there are enough signatures. This is going to be on the ballot in November. The idea is that PAGA would be eliminated, that individuals could not bring PAGA actions. Only the labor commissioner could bring a PAGA action. There would be no attorney's fees that would be able to be recovered under a action for fair pay and employer accountability. But what concerns me about this statute is that or potential statute, if this is voted in by voters of the state of California, if there's a potential violation, the employer has the opportunity to go in a private room outside the presence of the employee and discuss the matter with the representative from the labor commissioner's office. That concerns me quite a bit. And as far as fairness of this statute, but I leave it to each of you to decide as whether or not this specific statute would deal with what, maybe the perception that PAGA has gone too far. Is this going too far to the other side? But this will be on the ballot. They obtained enough signatures so that it will show up in November. So I once again encourage you to take a look at the Fair Pay and Accountability statute and look at who put this together so that you have a true understanding of what's going on. Let's go back to our updates. For PAGA, by the way, there is no right to a jury trial. It is purely, if it goes to trial, it would be a bench trial. And that's the LaFace versus Ralph Groceries. I've included that in the materials for you. One issue that's popped up, and this is an article that came up, you may be familiar with as far as AB 51. AB 51 was passed by our legislature that provided that any contract or agreement that provided for arbitration was, at the time of hiring, was null and void. It was challenged in federal court. The trial court said the statute was unconstitutional. However, the Ninth Circuit determined in part that that preventing AB 51 from going into play was inaccurate. It was from the standpoint the injunction should not issue, that AB 51 certainly could apply. However, there was a petition for an in-bank review before the Ninth Circuit. And so now, because of the United States Supreme Court granting certiorari in Viking River Cruises, the Ninth Circuit has decided to delay hearing on AB 51. So when certiorari was granted by the Supreme Court, there are a number of plaintiffs' attorneys that were relying on the Ninth Circuit's potential for AB 51 to go through, but that's been all stayed now. So we'll see what happens and how that turns out. Let's go back over a couple other changes. I just want to bring to your attention. This was and is law now. This came into play in January 1st, 2021. Anytime that wages are owed exceeding $950, it is considered grand theft. And this is a situation where there are 2 or more employees, so that if an employer owes wages that exceed $950 or $2,350 for 2 or more employees, it is considered grand theft. And that was a change to the penal code. This is a section that we won't see from the standpoint of civil litigation, but it's certainly something that's interesting and to be aware of. Lastly, I want to finish on this, and there have been many folks that have been impacted by, obviously, the pandemic and COVID-19, but this is one of the ones that I think that we could all agree the legislature got right. Labor Code Section 2810.8 applies to the hospitality portion of our economy, hotels, arguably restaurants, and it provides that employees that were laid off as a result of COVID-19, they're required to receive information from the employer regarding positions that are available, or they're required to be hired. This will be effective, it's effective now and will last through December 31st, 2024, excuse me. And it's a heavy hitter. And I encourage you, each of you, to take a look at it. But if you know, or if you have former clients that were impacted because of the pandemic, and specifically hospitality, hotels, restaurants, and you can go through the definitions, the actual statute is included here, and it goes through all the different providers that were impacted. But mainly we're talking about hotels, airport hospitality, but it goes through the penalties and the rights they have. So I would encourage each of you to take a look at this. I want to thank you all. It's always a pleasure, and it's always good to see so many of you, and the names that I see that didn't want to necessarily show yourselves on Zoom, but as I indicated, over the years, I wanted to put together a toolbox or something that each of us can go back and refer to for our own practices, so that this type of program is pertinent to us, so that we're possibly in compliance, but okay, what about this, or what about our pay stubs, so that we're thinking about those just to raise the issue. And I felt that there were so many changes taking place in 2022 that I wanted to bring your attention to each of those. With that being said, I thank you all very much, and it's certainly a pleasure. Thank you.
Thanks, Scott. And just before, Scott, can you hear me?
I can hear you fine, Lori.
Okay. I want to thank you for the excellent presentation. I want everybody to know that all of the case law and the forms that you referenced, it's about 100 pages, available online. You can download it online. So if anybody has parts of it they want, or all of it they want, they can print and download it, or they can save that. Thank you, Scott. We appreciate all you've done. And just briefly, anybody have a quick question? No? Okay. So this is our first hybrid meeting, probably April meeting, which is third Thursday in April, will be back to Zoom. And May will probably be back to Zoom. And then in June, we're going to have the Rainbow Ranch meeting, where we have the presiding judge of San Bernardino County, the presiding judge of LA County come as guest speakers. It's a barbecue up at Rainbow Ranch. It's a lot of fun. And so I look forward to seeing everybody back in person in June. So we'll try this again probably around July, see how it works. Yeah, we have speakers up until I believe August, and then I'll get the rest of the stuff. So I want to thank everybody both on Zoom. Thanks, Scott. Scott, you did an excellent job. Let's have our round of applause for Scott.
Thank you, Lori.
Thanks, Scott. Okay, and we're going to close the Zoom meeting, and then the people that are here live, there's gift baskets. They're going to do the raffle for, so we'll do the raffle. And thank you, everybody. Good night, everybody.
Thank you, Lori. Good night.
Good night.